And now we're down to People of the State of Michigan versus David Thompson, file 24-3559FH.
Yep. David and Houghton, appearing on behalf of the AG's office.
Mr. Thompson is representing himself, and I'm advisory counsel in this matter, but I can advise the court there is no other case.
All right. So Mr. Thompson is now here, making his way to the defense table.
Yes. Oh, sorry.
Just call me David, you're on.
All right. Well. All right. So we are currently set. So you can have a seat. Just as you may have heard me say earlier, I don't take any thought. I have nothing to know about the case. I'm just going to tell you that, as I do to anyone here, for a final pretrial conference. Today is the last date in which to enter a plea pursuant to any pretrial agreement. Any plea from here on out must be done by entering a plea as charged. The reason I do that isn't to punish the defendant, isn't to punish anybody or encourage a case to go in any one direction. It's just to encourage you all to exhaust any negotiating that you've got to do, because everybody's got to issue subpoenas. Subpoenas have to be served by police officers or process servers. My staff has to issue jury notices. 60 different jurors have to reschedule dates and times and take off work, and employers have to do the same thing. So again, there's no punishment. It's just to make sure that we have exhausted all of our negotiating skills. So we have no resolution. The case is currently set for a trial right now. I know we have 2 trials set for February 18th. Excuse me, this one is set for 1 day. The other one was set for 2 days.
And I was going to, on behalf of the AG's office, I think that they're planning on it, ask that perhaps we keep both of those on. The idea being that we'll be able to conduct both of those trials in that 2-day time frame there.
And was there a jury demand, I assume?
There was.
Buckle up, guys. Today we're diving straight into one of the most bizarre court moments yet. A sovereign citizen storms into court demanding his dismissed charges be UN dismissed just so he can fight them. The judge, understandably baffled, tries to reason, but logic has clearly left the building. You can already tell this is going to be a wild ride packed with ego, confusion, and legal nonsense.
I'm going to move this to start on February 19th. So that way we have the 1 day to do the other file and the 2nd day to do this case. So I'll issue jury letters to 4 sets, 4 panels, 2 for each day. So Mr. Thompson, that means that even though your notices say that our trial was to begin on the 18th, we're going to begin it on the 19th. We do jury selection in the morning. I need to remind you that your choice to represent yourself, you're making that on your own. Is that correct?
That's correct.
You understand the court can appoint an attorney to assist you?
Yes,
Yep.
is.
I know. Yeah, I know he's helping you,
Yes.
but you understand that he's not really representing you. Like, in other words, he's not doing the cross exam, direct exam.
That is correct.
All right, and you understand that while it might seem illogical, I have to, by law, require you to follow the same rules in the courtroom, okay? So if you need to enter a piece of evidence an exhibit into evidence, you're asking questions, you're gonna have to follow the same rules, okay? And just make sure you say yes.
Yes.
Thank you. Every person has a right constitutionally to due process, and every person also has the right to represent themselves. And again, I also just needed to make sure today that you are making this choice to continue without counsel. In other words, representing yourself on your own. Is that right?
That is correct, yes.
And the key issue when I say on your own, no one's forcing you, no one's pressuring you. It's your choice.
They are not.
Okay, copy that.
May I?
Yes, sir.
It's my understanding, Your Honor, that there's a conflict of variance in the law. Equity should prevail. I'm prepared to wrap this up and settle all of this. It be done here in this venue that's exclusive of Article 3 Constitution.
Alright, guys. If you thought part 1 was unhinged, wait until the defendant tries to lecture the judge about constitutional rights while completely ignoring actual court procedure. He demands jurisdiction proof, misquotes outdated legal doctrines, and keeps digging himself deeper. The judge stays calm, but the courtroom patience is running on fumes.
I appreciate that interest, but I can't. And let me explain to you why, very briefly. The law and the constitutions for both the state and the United States direct that each side, and that's important, each side has the right to a trial with a jury of 12 impartial persons. And I'm really just sitting here, I don't know anything about the case other than what I see on the charge sheet, which just tells me what there's 2 charges of failing to pay child support.
Correct.
If you all can't negotiate that between you, I don't really get involved other than monitoring the cases and making sure I know when I've got to be here and what's going to trial. I don't get involved. And even now that we have a trial by jury, I'm not involved other than I'm telling that I run Tiger Stadium here. I mean, this courtroom, and this stadium will be available for the 2 parties. That's it. Okay. So I appreciate that might be your interest and that might be an objective. I can't make a ruling unless there was an appropriate motion. Now, in a criminal case, you can't file a motion to dismiss. I'm always surprised by how many attorneys, not these 2 gentlemen, would file a motion to dismiss in a criminal case. You can't do it. You can in a civil suit. That would be different. But here we can't do that. The law does not allow me to resolve this case unless you are all doing a trial without a jury. Since you're doing a trial with a jury, all I'm in charge of is monitoring Tiger Stadium. Okay?
Could you please repeat yourself the last 2 sentences, because I heard something and I want to make sure I heard it correct.
Hopefully I got it right. You can't do a motion to dismiss. Well, you can in the middle of the trial when the prosecutor rests. If the prosecutor doesn't prove each element, then you can do a motion for a directed verdict pursuant to Michigan Court Rule 6.429. Either 429 or 419. I think it's 429. You can do a motion for a directed verdict at that time. Until we get there, I can't dismiss a charge. There's some other rules, like if he violates the 180-day speedy trial clock, right, and you're sitting in trial in jail. But other than that, there aren't any ways that I can dismiss the case unless this case is before me, there's no jury, and it's in a trial. So if you requested and waived your right to a trial, by the way, Mr. Denhouten would have to waive his right to a trial, and I would have to agree. Since you both have told me you want a jury trial, or at the very least Mr. Denhouten has, I can't decide the case. Okay, that's all.
That's what.
That's okay. It's all right. That's what I'm here for.
I do appreciate you bring up the Constitution, because the arrest regarding when I was arrested in this matter was done ex parte. I had no notice of this.
Here's where things start spiraling. Our sovereign citizen now claims he's a private man acting in special appearance only, whatever that means in his legal fantasy world. He tosses around legal terms like confetti but can't answer basic questions. The judge, clearly over it, begins tightening the reins. Watch the slow unraveling of courtroom tolerance.
It's okay.
Their client.
An arrest warrant can be issued ex parte. The law allows that. There are rules that allow a district court judge or magistrate to issue an arrest warrant based upon a complaint.
Under the rules, but where does it say that in the Constitution? Because I've been reading that puppy backwards, forwards, upside down, sideways.
It doesn't. It just says it just says an arrest without a warrant is illegal. But the Michigan law doesn't, Michigan law tells us what we can do, or not we, but law enforcement can do, because they don't work for me. I don't work for them. They have issued a warrant.
Right.
And they did it according to the rules.
Yes.
Yes.
And Marbury versus Madison, any law that Congress or any legislature passes, if it violates the Constitution, it's null and void on its face. I'm not here to argue, I'm just
That's okay.
making you aware
Uh,
of
it's-
what's happening.
It's been a long time since I had that class, which was common law, where we had to deal with Marbury versus Madison. I'm aware of it, but as of right now, there's nothing to address. So bond continues. We'll see you on the 19th, sir. Thank you.
At this point, it's not even a hearing, it's a one-man circus. The defendant accuses the court of violating God's law, challenges the prosecutor's mere existence, and insists on defending himself in a case that no longer exists. The judge drops truth bombs like anvils, trying to steer him back to reality, but this guy's living in a legal dream world.
We're on the record today, 28 Circuit Court here in Missaukee County. Our first case this morning is People versus David Thompson. This is file number 25-1379-FH. Mr. Thompson, you can come and take a seat. I don't know which attorney's handling it. So.
We are David Deadbeat on behalf of the people.
Court recognizes the defendant, Mr. David Glenn Thompson, who is now at the defense table, and he is currently representing himself in this file. Mr. Thompson, as you might recall, I just need to go over a few things the law requires me every time. Do you understand that you have the right to hire your own attorney?
That is correct.
And you understand that you have the right to have the court appoint an attorney to assist you if you cannot otherwise afford it?
That is correct.
And you also have the right to self-represent pursuant to the Constitution. You understand?
That is correct.
And you are electing to represent yourself. Is that correct, sir?
I am, Your Honor, yes.
And I think you've represented yourself in this file the entire time.
Yes.
And through district court. Okay. All right, so we're here today for two things. The first is we're here today for a pretrial conference. The pretrial hearing today is just to find out where the case is going. The case probably, yes, just recently bound over to the circuit court after going through the preliminary exam phase in the district court. And I see that the felony information was filed on February 6th. And the court then subsequently issued, assume I did. Yes, a scheduling order. Actually, that was done on February 5th. No, it looks like the information was dated February 5th, but filed on the 6th. We're here again today for a pretrial conference hearing. Mr. Thompson, the only thing we do at a pretrial conference hearing is just to find out where the case is going. If there is a resolution of any kind, you guys can tell me. If not, then I'm going to ask if there are I'm going to ask a couple other questions. The first thing here is see that the defendant is pending charges, and I didn't say what they were. Looks like there are 2 counts for a possession of a controlled substance. All right, Mr. Thompson, is there any resolution between this case? I'm sorry, in this case, as far as you know?
Your Honor, I believe there is.
Okay. Well, hold on. I just got to ask the other party first, because a resolution means an agreement. Mr. Denhoughton, are you aware of any pretrial agreement?
I'm aware of that.
All right, thank you. That just lets me know that I've checked off that blank. What do you think is the nature of the resolution then?
Your Honor, I made a deposit with an ex parte hearing regarding another matter, equity taking jurisdiction to avoid a multiplicity of suits, putting up consideration for full accord and satisfaction and settlement and closure. To my knowledge, from what I understand, it includes all matters and all liabilities related. Now, I did realize that I should have directed the clerk to deposit that in accordance with the Judicature Act revised in 1961, Act 236, under Section 600.576, depositing funds, stocks, or securities with the court clerk pursuant to court order is discharged from further liability. And in that matter, I was the payer, so I did that. And I'm still trying to make sure all of this gets settled in closure in honor.
Things heat up fast. The judge finally lays it out. This case was dismissed, it's over, and there's nothing to fight. But our sovereign hero isn't done. He pleads, even begs, for the court to reinstate the charges, so he can win and prove some non-existent legal theory. It's both hilarious and sad watching someone chase a fight that isn't even there.
Oh, okay.
That would be another one of those envelopes that you.
Yeah. I understand. Okay.
If there's any other instructions or
you
my duty that I'm aware of, but I'm willing to correct my mistakes.
Okay. Let's take a quick look here. And you were giving me a reference to the Judicature Act, and I know it's 600, and you referenced the
576, Your Honor.
Okay. And how do you think deposit? What did specifically again did you deposit?
A certificate of security.
Okay. And so, what security was it that you tendered?
That was consideration
For
any outstanding liabilities, Your Honor.
okay. So your deposit of this certificate of security applies to how much was it for?
That it has been unassessed and unknown at this time, which is what I'm seeking further from the court assistance in.
All right. So, and you think that somehow takes care of this particular file?
Due to the fact that where there's a conflict and variation in the law between common law and equity, Your Honor, equity shall prevail, and equity takes multiple jurisdiction to avoid a multiplicity of suits.
All right. So, are you charged with the possession of controlled substances in more than one case?
No, Your Honor, that case, I was a payer, which falls into this with the 600-576. And to my knowledge, a trust running in the background deserves to be heard in equity.
So in this particular file, you don't owe anything.
My knowledge, I do not. I have
No. So
my knowledge, I am free and clear of liability, Your Honor.
No. Liability is a different word. Liability doesn't apply here yet. Right? There's no judgment that says you owe anybody money. So there's no liability.
Thank you for correcting me.
Now the courtroom reaches peak absurdity. The sovereign citizen continues to argue in circles, bringing up maritime law, strawman theories, and more legal gibberish. The judge shuts it down hard, refusing to play along. At this point, it's not a legal argument, it's a philosophical crisis happening on court record. And no, he still doesn't get it.
Now, the question here is there a resolution to the case? Filing whatever you think you filed doesn't resolve this particular case.
I understand, Your Honor.
Okay.
In equity, I thought that they took jurisdiction to avoid multiplicity of suits. So
No. Multiplicity is something different. Multiplicity is generally used if you've been charged with the same act more than once, or if you've been tried more than once, then that becomes double jeopardy. Multiplicity is something entirely different, unless you're telling me you've been convicted of the same offense already before, which I know the answer is no.
I have not.
It's okay. So, I'm sorry, sir, I cut you off.
I do have evidence that I did deposit with the prosecutor's office of potential resolution.
Okay, so you made an offer to the prosecutor to resolve the case?
Yes, Your Honor, and I've got the green card resent.
That's okay. And so what happens here is I'm just the manager of this small version of Tiger Stadium. And I always use Tiger Stadium. By the way, I don't even watch baseball. But anyways, this is my little Tiger Stadium. All I need to know is that somewhere in the future, and the date is currently on a piece of paper, looks like that is May 8th, May 6th. May 6th, we've got a game. It is the Tigers. That's his home stadium, so we'll say that's Mr. Denhound versus the Twins. That's Mr. By the way, I like Minnesota, that's fine. But all I need to know is, are we playing baseball on May 6th? If the answer is either yes or no, we're going to get two bites of that apple. Today's the first one. The second one comes at the final pretrial conference. So today, do I keep the game currently scheduled People versus Thompson set for May 6th. That is all I'm here to do. Now, if you and Mr. Thompson or Mr. Denhoughton reach an agreement, that's between you guys. I don't care what you guys deal with right outside. That's nothing to do with me. Mr. Denhoughton says they don't have an agreement, which means your offer has been, at least at this point in time, rejected.
Complete. The judge, stone-faced and done with the nonsense, ends it all by confirming, once again, that the charges are dismissed and the court is adjourned. The defendant walks away still confused, still wanting to fight something that doesn't exist. You truly can't make this stuff up. Don't forget to like the video and subscribe to the channel, and we'll see you in the next Courtroom Showdown.
So, now the next question here is, so that means we don't have a resolution today. I don't know, I don't understand necessarily the theory of Mr. Thompson resting on the statute that he referred to. This has nothing to do with liability, because so far, it doesn't end the case. You can't pay off a fine until I order a fine. So, therefore, the next question I have is, and I know that Mr. Thompson is currently on bond, so we don't have any issues there right now yet. I know there's a bond petition. The next question here is, have you gotten all the evidence, the discovery in the case, like the police report, any body?
I'm not sure.
Yeah,
Sorry,
it's okay. It's okay.
I'm not sure that I have it in total.
All right. So the best thing you can do is you can look at the police report, and if, for instance, it says, well, hold on. Have you received a copy of the police report?
I believe I do have one, Your Honor.
Have you received, it should be a lab report from the Department of State Police, the Forensic Crime Lab?
I'm not sure if I've got that yet.
Mr. Denham, has there been a crime lab report yet? Sometimes they're running behind. Nothing works like it does on television.
Your Honor, I believe it has been submitted, but I don't believe we have a copy of it.
All right, so that means I turn over here, and I'm just going to say on my discovery issue, still.
Your Honor, I stand corrected. I do have a copy of it.
Never mind, I don't have to write that down. The next is was there a prelim?
There was, Your Honor.
Okay, let's make sure that I ordered the prelim transcript.
There is audio and video that has been submitted as well.
Okay.
He doesn't have a copy. I'm happy to send another copy.
All right, so I see that the transcript has been ordered by my office. The transcript of the prelim will be prepared and issued to both the prosecutor and to the defendant. Now, the next question would be, I'm sorry, if you have received those. You say you think you have, so I'm just going to tell you what you can do is look at the police report. And typically on the last page or two, it will report whatever exhibits they may have collected. Let's say, for example, this was well, I don't use an example, let's just use the charges. If there was some kind of baggage, that will be put into evidence. That'll be listed on there. Don't get the baggage. You'll get the test of that baggage. Now, you should also be able to get the chain of custody, which should generally come. So you just want to make sure that there's the chain of custody. Now, if the defense chooses ever to have a substance retested, it can ask for that, but it pays for it you would pay for it on your own. You'd have to find a lab, and then you'd have to come and have me give an order that says, hey, police agency, send it to that lab.